So, so Rosalia, we are online, we are live, and thank you very much. It sounds scripted. We've just gone through recording in conversation with a beautiful mind. It just seems like a little strange, but thank you very much being part of the symposium. It's always nice talking to you. It'll be nice listening to you. And the format, you introduce yourself, you take it forward. I come in when you want me to come in. Please.
Okay. Well, thank you, Vikram. Well, first of all, like I said earlier, during a conversation with a beautiful mind, um, I'm honored, first of all, that you asked me to be part of the symposium. I had the opportunity to listen to some of, not all of the speakers, since there's so many, and I would like to eventually listen to all of them. But I'm very honored to be among the number of speakers that you've had on this symposium so far. Very, very fascinating. I hope I can contribute something today. My perspective is going to be mostly on, it's just a general overview of Canada's mediation culture, but it would be more in the modern sense, like I mentioned, because if we were to go into the past, we would need an anthropologist basically to do the research, and that's a symposium in itself. Also, I just wanted to point out that I'm just going to go through, like I said, an overview. I might touch a little bit about on Indigenous, but not much, because that is not my area of specialization, and we would again need a full hour or a couple of hours on that, and a specialist on it that's specialized in the Indigenous culture.
But
So
only thing
that
with the,
being said,
but Rosalia, you have to introduce yourself also. Because that introduction is for that show. This one, it hasn't happened. So a brief one, just a brief introduction.
okay, so who am I? Well, first of all, I'm a Canadian. I'm born in Canada, in Montreal, Quebec. Of Italian parents, as you can tell from that slight accent or heavy accent or whatever you want to call it. I'm an accredited mediator with IMAC, which is l'Institut de Médiation et d'Arbitrage du Québec, and a member of ADRIX, which is the Alternative Dispute Resolution body in Canada. I'm also a Canadian civil servant. I'm a lawyer, legal, let's say, trained in law, in civil law, and also international law, both private and public. I have also graduate training in conflict management, conflict resolution from graduate school also. So that's it. I don't know if you want to know more, but
Okay,
those are my credentials so far.
No, if anyone wants to get to know you, they should watch this episode of In Conversation with a Beautiful Mind. They'll get to know more about you. So you want me to, yeah, you want me to share the screen? I can do that, and I can start your presentation, whatever you say.
Well, yeah, let's get into the presentation, so that we can get the full hour in. Basically, like I mentioned, I'm going to be focusing on Canada's modern mediation culture, okay? Which is, from let's say from the 70s until today, because that's our modern mediation culture. If we want to go into more its origins and whatnot, honestly, we would need the help of an anthropologist. And I'm not an anthropologist. So I'm going to focus more on Canada's modern mediation culture and the influence of the legal system, Canada's legal system, how it helped evolve the mediation practice in Canada. So if we go into the topics of discussion, like I said, I'm just going to give a very, very quick, brief review of what the Canadian system is. Just going to touch where the Indigenous communities in mediation they would fit in and they will fit in. The Indigenous communities are the First Nations. I should not say fit in. I'm sorry about that. very little bit about the Indigenous communities. The Canadian legal system, which is more what my area where I would, my understanding, and the influence on the development of mediation. Also how the Canadian legal system influenced the mainstream interest in mediation, including education, and briefly touch upon government administration and mediation. That itself is a presentation in itself, which is, so I'm just going to really give you a very, very quick overview. What are the areas of practice in mediation? And it's not an extensive, it's just, again, an overview, and where are we headed? What's the future of mediation? I think it applies not only for Canada, but more or less for many globally, where's the future of mediation? So if we begin, from what you'll see, the Canadian system, basically, it's as you can see from the map in front of you, for the Canadian system, our system, it's a federation of provinces. You see, we have 10 provinces and 3 territories. The 3 territories are at the top. We have the 10 provinces, first of all, from British Columbia all the way to Prince Edward Island. Those are 10 provinces. And then we have the 3 territories at the top, the Yukon, the Northwest Territories, and Nunavut. Nunavut is new. It wasn't considered a territory before. Before it used to be part of the Northwest Territories, but since 2016 it became a territory. So that's as a recognition of the Indigenous, the Indigenous culture of our society. So Canada itself, it's what was I going to say? For the past couple of centuries, Canada is the colonies of England and France. So because of that, it adopted the traditions and the practices of the courts of those countries, and it's now an independent federal state with 10 provinces, as I said, and 3 territories. It became independent with the BNA Act of 1867. So like I said, it's modern compared to other countries. And under the BNA Act, the British North American Act, that's the BNA Act of 1867, the provinces and the countries and the federal have different jurisdictions. Okay, for example, it's article what differs the jurisdictions between the provinces and the federal government are Articles 91 and 92 of the BNA Act. So if anybody's interested in some Canadian history and Canadian Constitution, you can check the BNA Act, and it'll give you we call them les compétences, the competencies of the federal jurisdiction and the competencies of the provincial jurisdiction. Okay, so like I said, because of our background, it's influenced by a common law and civil law system. Now, most of the provinces that you see before you, from British Columbia all the way to Prince Edward Island, except for Quebec, they're all common law systems based on the British system, and Quebec is a civil law system based on the French system. And so because of that, because of Canada's multiple jurisdictions, sometimes mediation in Canada, this mediation in Canada is actually quite similar in the practice itself, but because the provinces are different jurisdictions, like different provinces will obviously incorporate, some provinces are quicker than others to draft legislation with respect to mediation practice, even though the practices are similar in the provinces, in the different provinces of Canada. It's just a question of how they incorporate the practice itself in each province and when, or basically for accreditation and licensing, that's the only big difference that I see. So if we go to the next slide, As I said, um, the mediation and the Indigenous culture in Canada, um, the Indigenous culture in Canada has a long history of. I put ADR methods because it's not only mediation; they have different alternative dispute resolution methods to resolve disputes. Um, Mediation exists obviously for thousands of years in the old world and in Canada as well. But in Canada, it's because of the Indigenous people, because they were the First Nations. We basically colonized their territory, but they were already in their practices, in their traditions, they were already incorporating, let's say, mediation practices and different forms of alternative dispute resolution. And the practices themselves that the Indigenous communities, the mediation practice itself, they're diverse. They're as distinctive as the various tribes and as their cultures. So I'm not going to get into it because I'm not a specialist, like I said, in that, and we would need either an anthropologist or someone from the Indigenous community that can actually prepare a study on that. It would be quite interesting, I'm sure. What I do, what in my research for this presentation, I came across this reference that you see here from Winona Victor, and basically they summed it up as that there's three modes of ADR processes which are used in. I should have written the Indigenous communities instead of Aboriginal. That's the old word. There's basically their practices are based on a little bit on our Western paradigms. They use negotiation, conciliation, and arbitration. But then again, they also have their traditional Indigenous dispute resolution methods based on ceremonies, and they're very there's and it's their particular the ceremonies are obviously conducive to their diverse cultures. And they also have mediation practices or ADR practices, which is a combination of both. That's about all I could say about the mediation culture. And what I can also say is that the legal traditions of the Indigenous peoples in Canada, basically the Indigenous peoples, they were completely displaced as waves of foreign settlers began to predominate here in Canada. Most of them came from Europe, different parts of Europe. And as the Europeans migrated to Canada, the Indigenous peoples became a minority, and they were colonized basically. So they were forced into legal systems of colonial authority. And since the early 1990s, the Indigenous political leaders and scholars, they started speaking out more and more. Well, and they pointed out that the theories and practices of that we use in dispute resolution in the practices of Canada, including the interest-based, because we use a lot of interest-based negotiation model, they're basically unsuited for the conflicts involving Indigenous peoples in Canada. They don't necessarily, although we consult and we work together, we try to work as much in collaboration. I'm talking about the federal government with Indigenous communities. They don't necessarily share the Western values which underlie the dominant ADR practices in Canada. And also the Western-based negotiations and dispute resolutions methods in the Canadian courts, they've been imposed on Indigenous peoples through colonization. And so it's kind of made it a struggle for them to be heard by, they feel that for them it's a struggle to be heard. So like I mentioned, the legal scholars and the representatives of the Indigenous communities, they've been providing insights on how Indigenous wisdom and Indigenous laws and the legal pluralism could help address conflicts involving Indigenous people. Canadian government is listening. Right now, I could say off the record that the push is to work with the Indigenous communities nation to nation. It's taking a long time to get there, but eventually we will get there. And that's what the objective is, okay? Because the Indigenous communities want to negotiate on social issues, for instance, on treaty rights and what on equal footing with the federal government, with the Canadian government, which is nation to nation. An example, if we go to the next slide, is the Truth and Reconciliation Commission in Canada, which took place from 2008 to 2015. Now, the Truth and Reconciliation Commission of Canada, which is TRC, okay, it ran from June 2008 to December 2015. It was organized by the parties of the Indian Residential School Settlement Agreement. Okay, there was an agreement that came out. It was established. Okay, because unfortunately in Canadian history, there was what you would call a cultural genocide that took place for over 100 years. From the 18 something, I can't remember the exact date, until the last residential school existed in 1996, if I remember correctly. Children of Indigenous cultures were basically removed from their reserve. They were taken away from their families, children as young as 4 years old, and they were placed in residential schools, which were run by not only the Catholic Church, but also, let's say, the Christian denomination churches. And they were stripped of their identities, that they could not speak their native languages. They had to naturalize to Canadian culture. And unfortunately, many of these children perished. Until today, there are still unmarked graves that are being discovered in different areas of Canada. So it's a dark, it's a little bit of a dark past for a stain in Canadian history. Okay. So there was this commission that was set up, and there's a lot of the survivors that were able to give testimony on their experiences. There are still survivors that are alive, and their stories have been documented. They were given an opportunity to share their experiences during public and private meetings, which were held during the country, were held across the country. As a civil servant, I had the opportunity to work on Indigenous files, and I actually went to the Truth and Reconciliation Commission when they presented their report in 2015 here in Montreal, and I saw some of the survivors. I could tell you that it was very emotional. Even if I talk about it now, it is. I still remember the feeling in the the room. It's very difficult, but the Canadian government is very, very committed to righting this wrong. So there's a day of observation, which is now what's it called? That is now a National Day for Truth and Reconciliation, which is going to be September 30th. It's the first time in Canadian history, and it's going to be a statutory holiday, which will be recognized, and it's a day of observance. So that's as much as I can say about the Indigenous. I'm sorry, I didn't expect to become emotional. I just brought back, I had an image when I was talking about the Truth and Reconciliation Commission, because I had an image of one of the survivors who had given their testimony, and I happened to be there. So I apologize Okay. Now, if we go to the next slide, which is should be Canada's legal system, the evolution of mediation culture. Okay. So basically, the 1970s and the 1980s were the pivotal point for Canada for interest in mediation and alternative dispute resolution in Canada. Okay. And that came about because of Canada's legal system. That was the push because of the overburdened courts. There was a backlog of cases at all levels, be it at from the municipal all the way to the federal court, and because of the constitutional, let's just say the implications that it could have, because of the backlog. Normally, cases should be processed within 2 years, and that's the norm. And if they're not, it becomes an infringement of a constitutional right, let's say, of the claimants, and especially in cases with dealing with criminal law cases and whatnot, and restorative justice. So because of this backlog, the legal system, they realized there was too much backlog. Plus, there was the costs also involved in court litigations. The access to justice, there was an implication on access to justice. People couldn't afford to go to court, and there was also people realized also that a lot of the cases were resolved out of court before they even got to court. Although they were scheduled to be heard before the court system, a lot of the cases never made it to the court system because they'd be resolved initially by the opposing counsels outside the hearing room, either within their offices or in the hallways of the court room. So that's when perceptions started changing, and there was a push for mediation. Okay, so there was also fatigue with the adversarial litigation, and like I said, the high cost and the overburden and excessive cases in the court system. Okay, so if we go to the next slide, the Canadian evolution of mediation. Now, most lawyers at the time and legal public scholars, although there was an interest in mediation, they knew very little about mediation itself, the process itself. They were trained in negotiation, the adversarial models, and win at all costs, and negotiate with a result, which would be more, if they practiced mediation, a form of mediation would be more evaluative, like twisting of the arm, But in reality, Canada had a Mediation Conciliation Act since 1900. Okay. Basically, the Mediation Conciliation Act, which was in the Canadian system, in its legal system, it was basically, it dealt with employee labor disputes. It was a response to labor and unrest and the union industrial action in the late 1900s during the Industrial Revolution, when labor unions started to pop up. Canada passed the Mediation Conciliation Act. So basically, labor unions, as many of you may know, that usually when there's a grievance with employees, they will go before a labor union, and the labor union has a grievance system. But at the time, even before they went into a formal process, they were already practicing some form of mediation. So because of that, the Canadian government passed the Mediation Conciliation Act of 1900. So again, if we go to mediation in the mainstream, the main stream interest in mediation, let's say the first Canadian court-based early Canadian initiatives in mediation were mostly in the family law disputes in the 70s and 80s. If we move forward from 1900 to the 70s and 80s, where mediation became more known, the first cases were in the early 70s. There were community activists that conducted already mediation experiments, and they started doing this in restorative justice, basically in mediation and criminal justice. But it was mostly with young offenders. There were mostly social workers that were involved. They were not really lawyers, okay? They were community activists and social workers who basically were already seeing the benefits of restorative. Those were the first cases of restorative justice, where they would sit down and try to, the offender with the offender-victim dialogue. It was more apologies more than anything. So those were the first experiences, and then from there, that influenced also family-based conciliation services. The family-based conciliation services, most of them were set up in Alberta around 1972. Then Ontario followed in 1973 and British Columbia in 1974. At that time, the public and private family mediators in Canada were also primarily social workers and counselors, and they were trained in family therapy. Along with there were also lawyers that were trained in that, obviously family lawyers, but not as many. Basically, interest in the lawyers that became very interested in. They saw the benefits of mediation in family mediation settings, and from the 1970s, and in the 1980s, there was the 1985, the Divorce Act was instituted. It was actually amended with no fault divorce in Canada, meaning that when we say no fault, it means you could get divorced. You didn't have to prove that the other party there was a cruel mental cruelty or whatnot. You just were separated for a year, and once you prove that you were separated for a year, after that year you could get divorced. But what was the difference? What the innovation with this act was that they imposed a few sessions of mediations between the parties to try to reconcile the parties, to see if they can reconcile before actually pushing forward with the divorce. And so mandatory mediation started initially just for the parties, but then they realized that they can also use the mediation to try to resolve custody disputes, that the parties may have with respect to the children, because obviously, during the divorce, it's always it's in the best, the judge always tries to rule in the best interest of the child. And they had social workers coming in and basically speaking with the children. So they got involved in the mediation, and lawyers also started getting training in mediation because so that they can participate and also hold the mediation sessions between the parties. And since then, and because of that, family mediation lawyers, they need to be accredited, because obviously the Divorce Act not only encompasses custody issues and but there's also financial issues. There's, the splitting of the resources of the parties. And so you have to be specialized in that. And because of that, any mediators that practice family law have to be licensed. And this is, they have to have a special accreditation. It's not just anybody that can practice family mediation. You can't just put up your shingle and say, I'm a mediator, I'm going to practice family mediation. You have to be accredited by the province that, in the province that you are practicing it. Okay. Also, there was also in the 1980s, and there were interdisciplinary civil society organizations. They were the proponents who began to form interdisciplinary national and provincial associations of mediation. It started expanding. Started seeing law societies support mediation. They talked to judges. They persuaded government officials to make laws or policies supportive of mediation. They saw that it was positive, and so there was a push. And it wasn't just for family law, but they realized that legal education in law schools on mediation should become also the norm, so that lawyers would be equipped with practicing mediation as a nexus to litigation. Okay, so again, the mainstream interest, if we go to the next one, a pivotal moment in Canada, in the Canadian evolution of dispute resolution, occurred actually in 1986. And that was when Canada, with the consent of the provinces, acceded to the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Canada and the provinces, they passed a new arbitration legislation, and that arbitration legislation was based on the UNCITRAL trial model law of international commercial arbitration. At the same time, most provinces also modernized their domestic arbitration legislation act. I know, Vikram, you don't like to talk about arbitration, but it's part of the history of the it's directly involved. It directly influenced the evolution of mediation in Canada. So I have no choice but to bring it up. The A word. Okay. So most provinces also modernized their domestic arbitration legislation at the time, and the Canadian Arbitration Commercial Arbitration Center, which was called the CCAC, was founded in Quebec, in the province of Quebec. And in British Columbia, they created the British Columbia International Commercial Arbitration Center. What else? So at the time, the center, they cultivated business in domestic. They worked mostly in domestic commercial arbitration. Mediation was a bit on the side. The arbitration was the main. They still had that mindset, the litigant mindset, and arbitration was considered, the alternative dispute resolution method to litigation. Mediation was still like, oh, okay, it's it's still on this. It's there, but it's not there yet. We're not there yet. Okay. But as time went on, the Canadian Arbitration Association, they keep following the lead of the United States, and they also became interested in mediation and the benefits of mediation, also in with respect to commercial disputes. They were also following the lead of UNCITRAL, which has a working group too, which is not only arbitration, but it's also mediation. Okay. So like I said, most provinces, they modernized their arbitration legislation, and that's it. So if we go to the next slide, let's see, mediation interest in the mainstream. So so the advocacies, there were many advocates for mediation. The strong proponents were, believe it or not, in the religious streams and also non-governmental organizations. They started getting more and more, their voices were heard more loudly. Believe it or not, they're not lawyers, but most of them were not lawyers. Lawyers, the legal profession, I wouldn't say I mean, they acknowledged that mediation was an interesting alternative, but they kind of saw it as, at that time, a little bit still, they were still reticent. They saw it as a possibility of growth in the industry, but they didn't consider it that serious. Their mindset was still with litigation, and the alternative, the softer alternative would have been arbitration at the time. So the advocacy for mediation really came from non-governmental organizations, and especially in religious entities and human rights, let's say human rights organizations. A lot of the religious groups, they wanted to retrieve dispute resolution from the courts, and they wanted their objective was to hand over the litigation to local community dispute resolvers who shared more of their views with respect to the values of mediation. Some the ones that were resisting, they believe that mediation should be a mandatory part of the formal justice system. That's more from the legal side, because they didn't want to transfer, let's say, mediation just to local communities. They wanted to keep it part of the legal system. And so from there, it started, there was much more of an interest for mediation. A pivotal point was in 1988, there was a report from that was issued by the in British Columbia from the on justice reform, from the Justice Reform Committee, and it was led by Ted Hughes. At the time, he was the British Columbia's Deputy Attorney General. Basically, his recommendations was to refer cases of mediation to publicly funded legal aid programs. So that a lot of the cases, especially smaller cases, with respect to not only young offenders, but also, let's say, small claims court, instead of burdening, the push was, instead of burdening the judicial system with small cases of $10,000, why not just give it to legal aid programs where it could be resolved at the local level, instead of, because the costs of the court system was too high. It didn't warrant the investment in the court system for small cases. In his report, he also recommended certification standards for mediators. He didn't just want to hand it over to local mediators, but at the same time, he recommended that there should be a certification, some kind of certification for mediators. So that was when it started coming into more of the mainstream. So if we go to the roles of judges and lawyers, in the Hughes report, he also considered the roles of judges and lawyers. Now, traditionally, the Canadian judges, they have limited role in their adjudication. It's always the lawyers that initiate the steps in litigation and harnessing the court administration procedures, to gain leverage to negotiations. But they, and based on the fact that, like I said, I mentioned earlier, it was noted that in results of more than 85 to 95% of the cases that were registered with the courts, a lot of them, they were resolved before trial. So there was food for thought there, and he saw an opportunity there for judges and lawyers to be involved also in to get more training in mediation, so that they can resolve the cases before going into litigation. That was the mindset. That was one of Mr. Ted Hugh's recommendations. So there was a shift in the responsibility of litigation was no longer left entirely in the hands of lawyers, but also to their clients. Okay, and basically, he prepared the groundwork for thinking about judicial case management and the judicial dispute resolution. That was the beginning of judicial dispute resolution, and that influenced the codes of procedures of in the different provinces to include. I wouldn't call it mandatory mediation sessions, but strongly recommend mediation proceedings between the parties before going into litigation, for the lawyers to consider that in the different, whether be it commercial, civil mediation, civil or commercial cases, or family law. Family law was already integrated in 1985. So it was also recognized that lawyers and judges needed more formal training in settlement skills. And he recommended that the public be provided also with more information about mediation. So there should be a more promotion on mediation by the law associations, be it the Canadian Bar Association or the BC Bar Association, or whichever bar association, legal associations from the different provinces, to promote mediation and to develop standards for training. So that brings us to education and training. I think I just did the mainstream. That's right. So that brings us to education and training. Basically, in 1989, the Canadian Bar Association had a task force report on alternative dispute resolution, and they recommended the development of dispute resolution education for law students, because they figured if we have to start with training for lawyers, we have to start at the beginning, and we have to start in law school. So for law students, and also, of course, for lawyers and judges, and for the general public also. Okay, and that's why, that's what influenced also the development of so many private organizations, consultants that became specialized in alternative dispute resolution and mediation and in arbitration, and start giving out training, whatever. So that started that ball rolling. Okay, so that not only were they educating judges and lawyers, but they were also educating the general public, and the law associations. Their responsibility was basically to ensure that there was this kind of training in the legal curriculum at law school, and also in the continued training for lawyers and judges. So they set up continued education courses in mediation, and they became more available. And from there, they started the legal associations, the law associations saw that also there was a lot of training, which was given it also to the public. So they saw it as an opportunity for growth also in the mediation, and they also did see it as they saw that the public training, non-lawyers, they saw them a little bit of as a threat. So they started certifying, legal associations started certifying their lawyers, their judges, their legal professionals as mediators, whether it be in commercial, civil mediation. That's what they started with, and now they've expanded to different areas. Now, the Canadian training in mediation at that time was heavily influenced by the interest-based approach, which was developed by Roger Fisher and William Ury at Harvard. And in fact, I took mediation training myself as a graduate student in the Faculty of Law at the University of Sherbrooke, and that's exactly they have exactly the same curriculum as they have at Harvard University, but it's given in French. That's the difference because it's in the French province. And from there, I became accredited as a mediator after so many. It was a graduate degree and so many hours of training, and I had to do an internship and whatnot that developed from there. So that's an influence. But my training at that time was greatly influenced by getting to Yes, and obviously all the other doctrine that came out after following this groundbreaking little treasure, which we still use today, which everyone uses, and it's great to carry in your pocket. It's a nice little toolkit to have. So now I can't, I know Vikram, if we go to the next slide, again, I'm going to go to the 8-word, arbitration versus mediation. Like I mentioned before, during the 80s, there were ideological and turf struggles here in Canada between Canadian mediation organizations and the arbitration organizations as they tried to develop the qualification standards. Okay. Arbitrators, they didn't really believe in, initially like I said, they saw mediation as, okay, that's like the last resort. But their first ADR, alternative dispute resolution method of choice would have been arbitration at the time. But nonetheless, many took mediation training so that they could position themselves. Many lawyers I'm talking about in the legal profession, although their preference was towards arbitration because of their litigation background, they did take mediation training so that they could position themselves for what they call the growth industry. Basically, there was always that competition that they felt, also from mediation proponents, that the echoes were that the legal profession was basically had a monopoly on mediation practice itself, that the lawyers would take most of the mediation cases, which is not, that has evolved since then. And today, there's room for everyone, obviously. More lawyers obviously are trained in mediation. They are accredited as mediators. They're accredited as arbitrators, but there's also people from the general public from different professions that are non-lawyers that are accredited mediators. But again, the basic training was in interest-based mediation. Okay. At that in 1996. Like I said, that came from the 1996 Canadian Bar Association task force report that there should have been more training. The main accreditors in the 80s and 90s were the law associations, and whether it be the bar associations, or in Quebec, there was also, we have notaries. So it was the Chambre de Notaire de Québec, or the two main institutions in Canada at the time, and they're still in existence, is the Institut de Mediation d'Arbitrage in Quebec. I'm talking about Quebec now, and for Canada in general, it's the Canadian Commercial Arbitration Center, which became the ADRIX, Alternative Dispute Resolution Center, Canadian Alternative Dispute Resolution Center. Okay, so if we go to the next slide, I mentioned this law schools teaching. Like I said, by the 1990s, most Canadian law, because based on the Hughes report, which I mentioned earlier from 1986, by the late 1990s, most law schools already offered at least one course, resolution, and courses in mediation, and arbitration, as did the law societies, not only in bar school, but also in continuing education for the lawyers. So now they're more standardized. They've developed. There's obviously the ones that I listed here is not an exhaustive list, but I would say they're one of some of the first law schools that had that were teaching and that they had research in mediation. Okay, so as you can see, there's the Windsor Essex Mediation Center. The University of Victoria was one of the leaders, and they were actually one of the first in Victoria, in BC, in British Columbia. They also had a practical a legal clinic for their students, which was the Victoria Dispute Resolution Center, and that was developed in 1986. So they were kind of the pioneers. And they had a clinic, actually the Core Conflict Resolution Clinic in Vancouver. They created the Conflict Resolution Clinic in Vancouver. Also in Toronto, Osgood Mediation Center at Osgood Law School in Toronto. The University of Toronto, they provide dispute resolution and professional responsibility. And again, the University of Sherbrooke, Faculty of Law, they were one of the more recent ones. They started formal mediation and ADR training, the whole program, a master's program, a certificate program, a diplôme d'études, DESS. Their system is a little different because of the Quebec and the French influence. It's based more on the French system, but they started in 1999. So these are some of the. It's not like I said, it's not an exhaustive list. This is just law school teachings and research, and there's a lot more that I'm sure that if we look into the curriculum of many other law schools in Canada, including McGill and Université de Montréal, they also have clinics now. They used to have, a lot of law schools are very, to give experience to their law students, they have legal aid clinics. Now, a lot of them are developing mediation clinics and alternative dispute resolution. And also there's law competitions, mirrored on their law competitions, like the international law competitions. There's also mediation. They're also very much involved in mediation international competitions. And I recall when I was in law school, I was actually involved in the William C. Weiss competition in Vienna, and this was in 1996. Okay, so that gives you an indication since when they already started instituting mediation and arbitration training in the law schools. So if we go to government administration, okay, I put this in, okay, but I have to say that it's really not exhaustive, because the Canadian government administration is huge, since like I showed you, there's 10 provinces and 3 territories, and everyone is distinct, and each one is influenced by, each province and each territory is influenced by its regional realities and their court systems and whatnot, although most of Canada is common law, except for Quebec, which is civil law. So there's in general, okay, I'm going to talk about the Canadian government, let's say, as an entity in itself. We have mediation practice. I don't know how many departments we have right now. I can't even think about. I can't think off the top of my head. All I can, to give you an indication, we're 200,000 civil servants across Canada. That gives you an indication of the magnitude, how big the Canadian Civil Service Administration is. Okay, so in each department, yes, we have mediation entities. I'm just going to stick to the mediation for now. We do have mediation entities, depending on the mandate of each department. They'll have mediators. But what is common among all the departments of the Canadian government is there's one entity, and that's for civil servants who have disputes, HR disputes or employee disputes. It's the Office of Informal Conflict Management, the OICM. That's across the board. We have that in every department has that. So if an employee has a dispute either between another employee or between management, their first they can file a grievance to the union, or they can go before the Office of Informal Conflict Management, where they can organize. They have trained mediators. They can have a facilitation session, dialogue, mediation between the two parties. It's informal. It's informal. Obviously, it's impartial. It's discreet. Obviously, all the fundamentals. Okay, so that's an aside. But before I go there, in the government administration, normally, there's the Privy Council. They're mandated with, we have commissioners because we have administrative tribunals. Okay, so the Privy Council is the department, is the entity, is the branch right under the executive cabinet that mandates the commissioners. Okay, and commissioners are usually commissioners are the equivalent of I wouldn't call them judges. They're adjudicators. That's the word. They're adjudicators, and in the various administrative tribunals, we have different administrative tribunals. There's, for instance, the investment tribunal, or the one that I worked in, the Immigration Refugee Board. There's many of them, okay? And they also manage the Privy Council at the same time that they name commissioners, which are adjudicators. They also manage a roster of federally appointed arbitrators for, let's say, investment tribunals or international investment tribunals, or mediators, okay? And normally, traditionally, the mediators or arbitrators that make it on these rosters are highly qualified, very experienced. When I say very experienced, they have at minimal 10 years, but 10 years is not considered much experience. We're talking about retired judges and retired lawyers. They're highly qualified and they're specialized. I would call them subject matter experts in the different areas because they've worked in that field, let's say investment and international commercial investment, or commercial international arbitration and whatnot, okay? So that's the level that that's the caliber that they're at. That's the caliber that of mediators or arbitrators that make it on these rosters. Now, the Ministry of Justice, okay, they basically used to have the Ministry of Justice. Their role right now, their mandate with respect to mediation or alternative dispute resolution is they service the different federal department. Their mandate is to work on the policy and and whatever policy, and obviously to ensure that legislation that is whatever legislation that's drafted with respect to mediation or arbitration is up to date and whatnot. They're also um, they were also mandated initially with the training. They used to have a program which was called the Interdepartmental Shared Mediators Program across Canada, and this ran from 1996 to 2012. I was actually part of this program. I was lucky to be part of it. When I came into the government, I asked to be part of it because of my work, and it was a wonderful program. Unfortunately, shut down in 2012. And basically, at that time, the federal government, the Ministry of Justice, I should say, not only were they mandated with any policy with respect to mediation and ADR definition and the legislation, they were also mandated with providing the training, whether it be by their own personnel, or they would hire outside the consultants. And I actually received training on principled. My first training was there on principled negotiation and mediation, and in conflict coaching. I actually received it through the Interdepartmental Shared Mediators Program through the Ministry of Justice. And that training was based, again, as I said, it was interest-based negotiation and mediation based on the getting to yes and the Harvard model. And and they were also they also serviced the different federal departments, which meant that they lent out mediators or co-mediators. Now, within the Interdepartmental Shared Mediators Program, they would lend out, if you were on that roster of mediators, which of co-mediators, excuse me, which I was part of, based on the area of your area of expertise or whatever you were working on, like your specialization within your departmental mandate, if there was a need for that similar specialization, you were called upon to go and co-mediate a case. And I actually had the opportunity to do that through this program. I had to co-mediate a case between two regional organizations from Quebec that were disputing. It was a dispute which had reached not only a regional, but on almost a national level, and it had affected a whole community in the Maritimes. And it was primordial that the dispute be settled, because we couldn't move forward with programs and certain mandates that were let's just say that were given to these organizations, to work within the communities, because there was so much disparity. So that was one of my first mediation experiences. It was a wonderful experience. I actually co-mediated with a very experienced mediator. And because it was, let's say, because it was a mediation session that had to take place within a community, we actually had an auditorium, and we had to facilitate discussion. We had to prepare facilitation sessions. We had to co-mediate, and we had to do individual mediations between certain individuals. It was quite an experience. It lasted a few months, but it was a wonderful experience. I have to say, unfortunately, that program was shut down because of funding constraints, and also because of the magnitude of, because of the fact that mediation grew within the federal government. It became too much for one department to handle mediation mandates for mediators across Canada. So there was a push towards establishing mediation entities and mediators and in all the different departments, depending on their mandates. And that's so depending on which department and depending on what their mandate is, you have mediators which are specialized in that, in the mandate of the department and in the subject matter that they deal with. I hope I'm being clear. Okay. So if we go to the next slide. So the different, like I mentioned, the different departments, like I said, the different departments have their own in-house mediators, and they deal with disputes arising. The disputes could be with stakeholders, with meaning organizations, or it could be internal. Okay, I'll give you an example. For instance, the Canadian Human Rights Commission, they deal a lot with discriminatory disputes arising from discriminatory practices. It could be in work related. They have, if you go on their website, they're very they have a very interesting process, because they not only have an investigative process, they have they can investigate the case. They have different measures that they can use, but mediation is one of them between the parties. They have independent investigation, a complaint system. They have, and then they have they also have a formal system of adjudicators, but they also have mediators. So before it goes before the adjudicators, the case itself, if it it's assessed by mediators and alternative dispute resolution specialists, and to see if it's a case for mediation, or if it's a case that we should go before a tribunal. So they have a very interesting system. I would say that they're quite advanced with respect to the mediation practice within their department. If there's a model to follow, I would go with the Canadian Human Rights Commission of Canada. Now, with respect to since we're talking about government administration and mediation, the Canadian government, with respect to international policy, well, as I mentioned before, it's a member of UNCTAD, the United Nations International Commission for International Trade Law, and it's also a member of the United Nations Convention on it adhered to the UN Convention on International Settlement of Agreements resulting from the Singapore Convention. But before that, in 1986, it had already adhered to the 1986 New York Convention, the enforcement of awards. So it's very much the Canadian, at the international level, the Canadian government is very much involved in at UNCTAD. They're a member. They're involved in the 6 working groups. Very dedicated. We have within the Ministry of Justice, we have lawyers, which are a team which works exclusively just to service the meetings for UNCTAD. We have a group of lawyers, a big team that exclusively involved in so they're specialists in that area. Also at the international level, the Canadian government is a member of the Group of Friends of Mediation at the United Nations, and this Group of Friends of Mediation was formed in 1996 at the UN from member states. But I think there were now there's about 56 members, and Canada was one of the initial members of this group. And it's basically, their purpose is to promote mediation and preventative dispute resolution at the international level. Everything dealing with preventative dispute resolution, mediation, dialogue, facilitation in disputes, in intrastate disputes and international disputes. And it's basically mirrored on the principles of the United Nations Charter. If you go to Article 1 of the UN Charter, you're going to notice that they do make refer to the this Pacific resolution of disputes, and also chapters 6 and 7 of the United Nations Charter, which deal with the Pacific resolution of disputes. Now, the provincial legislators, okay, like I said, in with the Youth Commission, the recommendations from the Youth Commission, a lot of the provincial legislators also started to reform their civil codes of procedures, so that they can introduce mediation in the practice of everyday practice for lawyers. Basically, they put the responsibility on the parties so that they can try to resolve the disputes informally, either by dialogue, facilitation, or mediation. And so lawyers are, a lot of them, most of them are also trained in, many of them, I should say, a good part in mediation, so that they can try to resolve disputes before, going into a litigation. And in Quebec, Quebec actually recently in 2016, although I'm sorry, I have to take although in family law mediation is mandatory since 1985. In family law, mediation is mandatory all across Canada, and for family law, for the parties to go to a few sessions of mediation. And also the lawyers that practice family law have to be accredited as family law mediators. In Quebec, also, same thing for family law, but in Quebec now, in 2016, there was a reform of the Civil Code of Procedures, and that's to promote private dispute resolution. Now, basically, it's not mandatory. It's just strongly suggested that the mediators, the lawyers go into mediation and try to resolve disputes between parties before going into formal mediation. So in the Quebec Civil Code of Procedures, it's not mandatory, it's just strongly suggested. And it's the reason why it's not mandatory. I remember when there were discussions going on with respect to the reform of the Quebec Civil Code. I actually was part of the discussions because of the Institut de Mediation et d'Arbitrage de Québec. And the issue was because of the fact that mediation should be voluntary. Most of the mediators around the table that took part in these discussions did not want to see mandatory mediation, but wanted to see it more as a suggestion and a promotion, so that they maintain the spirit of the whole spirit behind the principle of voluntary mediation. If you have a chance to, if you're interested, you can look at Article 2 of this new Code of Civil Procedures. You'll find it on the internet. So basically, what it says is that the parties are obliged to act in good faith and to be transparent and cooperate actively in seeking a resolution, either through dialogue, mediation, and and that the whatever is discussed is confidential. It's all the principles, the basic principles of mediation that are basically. It's the first time that it's a milestone for Quebec because it's the first time that it's in written legislation. So that's the milestone for our province. Now, when we go to the municipal administration, basically also the municipalities is the municipal, we don't only have the federal level, provincial, we have, obviously, and then there's the municipal governments, okay, which is, municipalities, the cities in each province. At the municipal level, also mediation is becoming also very rampant, and they actually most municipalities. I can speak for Quebec because that's my knowledge, but I can basically say that in most of the provinces, also in their at the municipal level, they have an office of the ombudsman, and they have mediators, and it's basically to deal with disputes. It could be with between citizens and any municipal entity. For example, I'll give an example here. We're dealing with systemic racism, issue of systemic racism, let's say in the police force. If somebody has a dispute, a citizen has a dispute with the police force at the municipal level, claiming that there's systemic racism, a person of a certain race was stopped because they are of that race, they can file a complaint and with the ombudsman's office, and a mediator will step in. They can file a complaint with the ombudsman office, but they could also file a complaint at the provincial level. I forgot to mention that, I'm sorry. It's la Commission des droits et protections de la personne, because that's dealing with discrimination, but that's a discrimination issue. But they can also file complaints with respect to anything, even municipal taxes, let's say the school taxes or whatnot. And you'll have a mediator that can try to resolve the dispute. So as you can see, mediation has evolved from, there is the idea, from labor standards all the way to, local municipal disputes. It has evolved quite a bit since the 1970s. And since 1900, I should say, with the Mediation Conciliation Act. So if we go to the next slide. Now this slide, basically, it's not exhaustive. I'm just mentioning the organizations and areas of practice. Obviously, civil society organizations are very much involved in mediation, community organization, and as well as private organizations. When I say private organizations, I'm thinking of consultants who also who provide training. Let's say there's a lot of there are a lot of many private organizations, many consultants which have popped up in the last 20 years, which give a lot of training on different areas of mediation. Now, what you'll see here, I mentioned what came to, which ones are the most blatant for right now, but I'm sure there's many more subjects. There's areas of practice. Now we have mediation in human rights and community mediation. Community mediation, I can give you an example. For instance, at the local level, we have the YMCA, which practices and which is here. We have the YMCA, which is in Quebec. I could say they're part of this organization called Equijustice. Equijustice means equal justice in English. And they practice community mediation, which is mostly based on relational, it could be in any subject matter except for family law and criminal court. For criminal offenses, they have their own, a different restorative justice system. But where in community mediation, you could have a dispute for elderly, let's say between two elderly people, or a dispute for estate, or even placing, let's say, a parent in a in long-term care, any type of dispute, except for, like I said, anything dealing with divorce or family or criminal. Again, I mentioned restorative justice. There's youth, there's elderly mediation. Oh, landlord and tenant mediation. We have a board here in Quebec, landlord tenant board, and they also have, before it used to be an administrative, it still is an administrative tribunal, but they have a mediation section. So before appearing before the administrative tribunal, the parties may opt to try to resolve the dispute through mediation. So they have that for landlord and tenant. Obviously, for workplace disputes, there are many organizations, and like I gave the example within the federal government, we have the Office of Informal Conflict Management. But there's also workplace disputes which could be mediated at the community level. Environmental and resources, I would say that's more non-governmental organizations that are involved in that type of practice, and also in land disputes and the government. And then, of course, international and interstate, you can have non-governmental organizations along with with governments, states that are involved in, and they practice mediation. Then, of course, there's the law associations, and there's private practice, obviously, lawyers and that practice mediation, and they specialize solely in mediation, and civil and commercial mediation and family law. Now, like I said, it's not an extensive list. It's just an indicator. Okay, I'm sure there's much more. Where I'm going with this is that which brings me to the next slide. I see mediation as a multidisciplinary practice. That's what I see. That's what's happening right now in the present, and that's where we're going in the future. Okay, there are more and more areas of specializations. I can see that there's more mediators that are specialized in certain areas. Like I said, they're considered like subject matter experts. Let's say land disputes, environment, international, whatever, or family. But I see it also as a growing practice. And it's not only, I also see this as a practice, and I'm not just speaking about the Canadian perspective now, I'm looking at it globally. I can see it going towards, it's a growing practice in all kinds of areas, and it's a growing practice not only for the legal profession, but also for non-legal, obviously, and we're seeing that more and more, as we see in non-governmental organizations. And there are many non-lawyers, social workers from every Okay, sorry about that. My computer just went. It just went. It just shut down. I'm sorry about that. Are you still there?
Yeah, yeah, I'm still there, waiting for you.
Okay. Well, I'm at
But,
the end of the presentation
but
anyhow.
imagine, Rosalia, where we are. We're at online dispute resolution, and that's the point your system decides to crash.
Exactly. Actually, it's perfect. It actually, it's like I couldn't plan it better. Um, it's like exactly online dispute resolution. Uh, what was I going to say? I was going to say that with the pandemic, now there's more and more online dispute resolution, and what we need because of online dispute resolution, we need more training, exactly for situations like this. Um, uh, how to handle technology and how to handle technology gracefully and how to know how to handle technology. I find there's a need for training for mediators, practitioners, and for the challenges of online dispute resolutions. For instance, your system shutting down, which, by the way, is something that happens quite regularly during. Sometimes I'm having meetings, and it was a huge source of stress for myself, for not only myself, for my colleagues also at the government. We're in the middle of a meeting, and the whole system goes down because imagine you're coast to coast and you have so many people on and bang it goes down. So I guess you have to just go with the flow. So basically that's where I'm going to end my presentation to go to the next that I think with where we're going is because it's a growing practice, there's more areas of specialization, and there's a growing number of mediators from all realms of society, not just lawyers. I think there's more training that's required for both mediators and practitioners, not only in the different areas, but also in dealing with you know the growing practice itself with the toolbox, the basic, the fundamentals, and for online dispute resolution, how to handle online dispute resolution, and also whatever comes up with there's also with online dispute resolution, obviously there's the not only the technical issues, but what would you call it, the privacy and everything which is attached to that. So I'll go to my next slide, and I would like to thank everyone for your attention, for staying with us throughout this long presentation.
Yeah, it's not going to be
And
that, Rosalia, it's
again,
not going to be that easy. You have to say it in all the languages that you have written there. You have to say thank you in all
I
of them.
can't pronounce. I can't read. Thank you, danke, obrigado, grazie, merci, tak, gracias, havla, achi. I can't pronounce some of them, and I can't. Some of them I just can't. I don't know how you say it in um, other languages.
Where is Hindi in all this? I don't see any Hindi there. Why
Hindu,
is
I don't know. I don't know if I could find it in Chinese. I don't know, but whoever's out there online, you can see it.
So this shows us the more international nature of the symposium. That's what I would say.
Yeah.
So, okay, so I can shut the screen share, right? Yep.
Okay.
So basically now it is question time. Rosalia, it's not going to be that easy for you to just give your presentation and finish. So one thing that's coming up is obviously the whole concept of colonization and the indigenous communities and their dispute resolution systems being affected. That definitely we see. And
Mm-hmm.
how do we undo that? Is there an undoing of it? Because I think there is some, at least in the indigenous communities, there is work happening. I think Martha is at least doing something. They're talking about doing something there. So that, well, that is where I am coming from, Rosalia, is that we have this whole colonial concept that dispute resolution is in the courts, and that's where you
Mm-hmm.
do dispute resolution. So even mediation connected with courts, just the fact that it's connected with courts just shows that the courts still feel that they are the place for dispute resolution. They're not being able to let go. Just
That's
let go.
right.
This is not your area. Your area is something else. And good thing, at least you're saying that there is a concept that if 2 years, I mean, there is at least a thought that, okay, if the justice is delayed by 2 years, it can be seem to be justice denied. 2 years is too
Yes,
much. It's still too much. I mean, I keep saying that even 1 hour, if an innocent person is lying in jail just because your justice system was not equipped enough, it is human right violation. It is denial of justice. How do you put a time frame to someone's time in jail when he's innocent?
that's
Even a
right.
minute, I mean, even in a minute is too much for that. So that part, those issues will keep coming up. But other than that, I think interesting other what are the interesting other things. I made some notes out. I just open those notes. So I think the Truth and Conciliation Commission part of it, and these children, the place that I saw this with, there's a TV series called Anne with an E. I don't know whether you saw that. Anne with an E.
And I watched some of that
Okay,
miniseries.
so there they had this situation where a child was picked up from one of these indigenous communities, and this Anne had to went there to find the child and all that. So that was my introduction to the concept. So otherwise, I mean, when you had the arbitration, I mean, to ratify the New York Convention, when you got the law for arbitration at that time, in that law was mediation part of that law? I didn't see that part. Did it?
At that time, if I recall, because I remember when that came out in 1986, mediation was there as an alternative also, but it wasn't practiced as much. It was the emphasis was on arbitration because it was more. Because I actually remember studying it in my graduate studies. Uh, Actually, that's why I got involved. I got interested in mediation because my initial introduction was arbitration, and it was in the New York Convention. I remember that. Plus, I remember at the time there was NAFTA, the North American Free Trade Agreement. I actually had to. I wrote a paper on Chapter 19, which was the informal dispute resolution process between the United States, Canada, and then it became Mexico also because it used to be the free trade agreement between Canada and United States. But then in the 90s, Mexico joined and it became NAFTA. Now it's I don't even remember the name now. It's changed so much. I have to look it up. Anyhow, so at that time, I remember that's why I got involved. I was interested in the New York Convention because they were referring to it as the enforcement of arbitral, the enforcement of agreements. Okay, because in NAFTA they would refer to the New York Convention. Okay, but I do recall that mediation was there, but it was like considered okay. It's there. It's just there. You know, but it wasn't as practical. It wasn't. It was a growing profession. Let's just say still infantile stages.
But I mean, because like being part of the government, when we talk about the fact that you are for low value disputes, you're saying that let's promote mediation and let's give it for free kind of thing to the people who are disputing, and all those discussions keep happening. Sometimes I feel that this state funded concept, isn't it really funding people's disputes? Aren't you just funding their disputes? Is it right on the taxpayers' money, for the taxpayer, that you're going out, someone is fighting, come, you come for free, we'll settle your dispute for free. I just feel there's and because you're part of the government, I keep obviously keep
Okay, well, the way I can respond to that is, well, you're paying, I said state funded, but you paid for that. You're paying through your taxes.
yeah.
So,
But what about the other people who are paying their taxes and they're go funding someone else's
well, we
dispute?
pay a lot of taxes.
That's what I'm saying. No,
We
but
pay a lot of taxes here, so that basically you already paid for that dispute, for the funding of that to resolve that dispute because you paid through your taxes. Trust me, if you ask anyone, they'll tell you. But that money, basically, that money goes through an organization. Okay, I'll give you an example. For instance, community mediation here. I could give you the one that I'm involved with, which is with the YMCA, and it's through an organization called Equijustice, which is equal justice. Okay, and I'm actually involved right now in a in a mediation. Well, actually, it's not going to go to mediation. We started the dialogue, but it's not going there. It's a case dealing with it's in an elderly long-term residential healthcare home for elderly, and basically, we had a few sessions with one side of the parties, because it's basically there's a group of elderly people in this resident that would like to get rid of the director, let's just say, because they don't like the way the place is being run. Okay, so when we had the first discussions with them, we realized I wasn't so sure it was going to be conducive to mediation. We invited the other party, but they never responded. And at the same time, they had a general, they're under, there's a, what do you call it? A conseil d'administration. I'm thinking in French right now, because the case is in French. So my mind is in French. What do you call it? Administrative body that runs, and they would like to get rid of the person. We had, let me see, we had 4 meetings with them, and each meeting lasted at least 3-4 hours. So can you imagine how much it would cost if an individual mediator, the average, let's say the average price of a mediator, a non-experienced, would start minimum at $150 an hour. Okay, more experienced, it's from 250 and up. Okay, so can you imagine how much how the costs rise up quickly? So basically, the organization itself that trained us, accredited us as community mediators, we got our X number of hours of training and practice and whatnot, is funded either at the provincial level or at the federal level. That money that they received from the federal government is well spent, because they trained the cohort that I was trained with. We were 16 or 17 co-mediators, and and they have at least another 10. Let's say we're 26 mediators, okay, that are providing free mediation service. So it's worthwhile. It's
but you're providing that free.
Yeah, we're providing it for free.
But
I mean, I'm doing this
you don't get anything
because
there. You're not
I'm
getting.
accredited in civil and commercial mediation, but I wanted to see what I wanted also, like, I like to learn, and I wanted to practice also on the community side to see what that was like. It's very different. It's very informal. It's less formal.
But the mediator gets nothing. You're saying mediator gets nothing out of that.
Pardon?
The mediator gets nothing.
No.
Look,
You give your time.
let me give you that perspective. There is one person like me who's only a mediator. So he doesn't have a
Okay.
government job. He's not an arbitrator. He's not got his practice as a litigating lawyer. He's just doing as a mediator. Now that you have provided it free, what you have done is you have affected my livelihood.
No,
So
I haven't.
obviously it's going for
I
free.
haven't.
Someone else.
I haven't. I actually, you would have had the same results as we did, because you would have maybe had 1 to 3 meetings maximum. Okay, or they would never have come to your door, first of all, because they can't afford it. They're elderly. They're on fixed incomes. There's no way they could afford your this is access to justice. There's no way they could afford your fees of minimum. I'm talking like minimal 150 to 250 an hour. Okay, there's no way. There's no way they could. They're on fixed income. The reason why they're in that residential home is because it's a lower income residential home. Anyhow, there's no way, because they're on.
Okay, so basically you're
So
saying
they would
something
need.
that it's like legal aid. It's like legal
Pardon?
aid. It's like legal aid.
It's
You
like
give it
legal aid. Yeah.
legal aid. Yeah. Okay. So
Yeah.
you think that in those situations when a person can't pay, then in that case state funding for mediators should happen
Yeah.
for the people who can't pay. If the other party
Yeah.
can pay, they should pay. Is that going to happen, or that's never going to happen? Look, if one party can't pay, not a problem, but the other party, if they can pay, should they not pay?
But that depends on the system. Depends on you see that's a very you're looking at it from the lens of the system that you're used to, and I'm looking at it from the lens of the Canadian system.
No, no, everywhere. It's the same thing everywhere. Everywhere. That's the problem. This is what I'm saying. Everywhere, mediation is coming for free to people. So obviously, they don't value it. Definitely, how would you value a free thing? You don't ever will
No, but you
value
know
it.
what, Vikram, I'm going to tell you something. I had a case. Okay, I'll give you an example. When I was saying that more and more people are becoming more specialized in certain areas, okay? In my mandate as a federal civil servant, I've worked for how many years? 12 to,
At least more than 20 years.
yeah, but for 8 of those years, I worked on Indigenous files, okay? And like I tell you, they're very complex, extremely complex, very sensitive. And when I went into that team, I had to get training. I was given training, mandatory training on the culture, which I'm still not, I mean, I'm not Indigenous, but you have to understand how to approach. It's a different mindset and whatnot. Okay. So, and then I had, and then in your day-to-day dealings, in your work, you learn more and more as you deal with the different stakeholders, and it's very political. Okay. And don't forget, you're representing the government. Okay. So since you're representing the government, you're always seen as the government, even if you have that label on you on your forehead, the government, okay, the enemy, okay, which we're not. But anyhow, so I had to always tread with caution and whatnot, but it taught me a lot. I acquired a lot of skills, soft skills, and a lot of awareness, which there's always learning to. Obviously, I always have to learn more. But that created an opportunity for me. In 2015, I was solicited for a case on a reserve privately, not as a government representative. Okay. Um, and that case it was a work related dispute. Okay. But it lasted, the dispute was, there was a systemic problem. There was really a systemic problem. There was everything in there, discrimination, you name it. You, I don't even know where to start. So I had to call in another mediator. It was too big for one person alone. Okay, I needed a support team. And that case lasted almost a year. Okay. Besides, I had to take time off work to go take care of that case. I had to ask for permission, obviously, which I did. I mean, and I had to ensure that it was not a conflict of interest, obviously, with the work that I did and the parties and whatnot. Everything had to be transparent and on the up and up and whatnot. Okay. And then, while maintaining confidentiality. Okay. So, but that case in itself lasted over a year. Now, on that reserve, they have a mediation service, which is free. Okay. And is given by their own people with Indigenous traditions and culture. Okay. So my first question, I remember when I was solicited, I said, well, you have a mediation service. Why don't you use it? And you know what the answer was? The answer was, we can't use it because everybody here is related. So, chances are your cousin is going to be mediating. There's, we don't have that, what do you call distancing? I'm like, oh, okay, yeah, that makes sense, obviously, So I was involved in it, and it was very lucrative, I could tell you. It was a lucrative case. It was an amazing case. It marked, for me, it was a milestone in my personal development and in my mediating career. I could say that for a fact. Uh, Not only for myself, but also for my co-mediator, who's a very experienced mediator, retired lawyer who became a mediator full time, like yourself. Okay.
Look, but the one area, of course, I'd get into that part, whatever I do, always get into this about someone practicing only as a mediator. What is the situation? Are they being able to do it or not? That obviously I'm going to get into. And the law interrelation to the courts and what is happening there. That. But before that, on the ombuds concept, is it really purely a mediation concept or is it a med-op kind of concept?
Is it a what?
Mediation arbitration, is it like that or is it purely the ombudsman is doing mediation?
It depends. It depends on the ombudsman, the way they set it up. I'll give you an example. The universities have a lot of the universities have an ombudsman, and basically it's not med arb. They have a complaint system, um, and they have dialogue, facilitation, and then mediation. There's no med arb in there. Okay, why, they're not going to bring the students in arbitration. Um, it's different.
Yeah,
So
those are
not it depends on the organization, what their mandate is. Like that's what I was saying. It's becoming more and more specialized. Like there's more what I call subject matter experts, and it's becoming more and more tailored. I find that the profession is becoming more tailored. Like before, we would just say mediation, but now mediation is it's too huge. It's too wide, the concept. I find that it's becoming more and more tailored to the specific needs of that organization.
no, but I was
So
just
that
thinking
what
like
they're going to do is that they're going to set up a system that basically responds to the realities of the type of disputes that they receive, and you know
no, but in terms of the like we have a banking ombudsman, insurance ombudsman. Do you have those kind of things also?
yeah, we do. We have banking, we have like I said, it's too huge. I mean,
No,
I that's why I was saying when I
no,
mentioned the list, like it's far from exhaustive. There's
no,
so much.
no. My only interest in that is the banking ombudsman only trying to help them settle it, or if they don't settle it, is that banking ombudsman passing an order? How is that working?
Well, in principle, they're supposed to be helping them settle it, okay? But if we want to, I mean, we're all influenced by we're all influenced by our environment.
Mhm.
So that depends on on the individual ombudsman.
Because here the thing is that the ombudsman actually, if it doesn't settle, actually passes an award. So it's not the way people understand. So that word is actually in a way misused. The
Mhm.
concept was that they help you settle, but it has gone to that extent when they pass an award. So if you now use that word to someone, they'll think that it is a situation where it is a mediation arbitration kind of thing. But uh,
Uh-huh.
but but tell me, Rosalia, is it actually possible for someone to practice only as a mediator in Canada?
Yes, yes,
Work.
there are. In fact, that's what I would like to do eventually. I mean, yeah, eventually that's what I would just like to do. Like, step
That's
aside from civil service and just go, just do
yeah.
mediation full time.
But do we have numbers on this that how many
I
mediators are
don't know if we,
there
we
and
don't have actual numbers right now. I mean, I have, there's not maybe there is a study out there, but I haven't seen it. There probably are, they probably have to start quantifying. But I could tell you for a fact that there are more and more full-time lawyers like yourself that have left the profession and are just solely mediating. I know quite a few. I know of a few, and I actually studied with them when I was doing the program at the University of Sherbrooke. A lot of them were older lawyers that retired from full-time. They didn't want to be lawyers anymore full-time, and they went into mediation. They opened up their own private practice in mediation. So there are cabinets, but the problem is a lot of them, like there's also the legal side. There's a lot of private practice that do both.
Mhm. No, I'm
But
just
then you do have, yeah, there are full-time mediators.
few, not too many,
You
not too
not as
many.
many yet.
Yeah, we have to get there. That's where we have to get.
That's
So
what we're evolving towards, and that's where I see the different people from different professions coming in, social workers, which they already start. I mean, they're already involved. Like
Yeah.
anthropologists.
Yeah, it has to
that
open
that
out.
are
It has to open up to a lot of people. It has to open up to a lot of other professions and everything. They should all be doing mediation. This is not a legal profession thing at all. And that's
It
what I
just
keep
started
saying.
off like that. It
Yeah.
started off like that because of the mindset of the
It's the
overburdened courts.
no, it's yeah, that is one part. Main thing, it's that colonial mindset. Dispute
Yes,
resolution is to happen with the court system only, and we are the people to come to. Just forget about it. It's all gone. It's not that colonial. But the way it's affected, like I said, the indigenous dispute resolution systems, the traditional dispute resolution systems, that we have to discuss, which we'll discuss on the last day after we go through all the sessions. But this is a
but
serious thing.
the indigenous dispute resolution, they have, like I mentioned, they have their traditional methods, but I'm
Yeah,
not a
yeah.
specialist in
No,
that
I'm just
area.
saying that
Honest,
yeah, but I'm just saying that the fact that it had moved away from that, they had this whole court system that was pushed onto countries. That part of it is a little bit
but
of a
it's moved away from that because the majority of the population is not indigenous. They're a minority. Okay, so that's a
yeah.
different mindset. The indigenous mindset is very different. It's a different culture. Okay, so you can't expect, let's say, Joe Blow, who's of European descent, to unless he conscientiously wants to practice indigenous practice. Okay, but the thing is, there's not much of an outside of the indigenous realm. There's not much of an open mindset towards that right now. I mean, probably that has to be promoted. That probably has to be promoted.
No, the
That
whole
that, that
idea.
that could be a growing um, area. There's opportunity for growth, definitely, most definitely. Because the values, the fundamental value system that they have is, I mean, it's based on ancient, not only their culture, but also ancient practices.
Yeah. No, that's what I'm saying. That what I'm trying to say is that through the symposium, we're trying to find out what's happening around the world. But I'm saying, and what we learn from there should be used. It should not be okay. These people do it, and they should be doing it. We should pick up from there. We should be taking up that in part of our practice everywhere. So that part of it, and I think we also need to learn what they're doing and how they're doing it and all those things. So that is why that knowledge on that was required. But the other thing
But
which yeah,
there are actually there are mediators that are interested. I told you I was part of a working group at Limac, which was the committee on indigenous mediation practice. Okay, and it was basically to have access to justice on for mediation on reserves. Okay, so part of that committee. Okay, these were the discussions that we were having. It's exactly what you're bringing up. Okay, that it should become more mainstream. Okay, but we're not there yet. It is something that they're starting, organizations that are specialized in mediation are starting to look at, but it's still something that needs to be developed. It's still in the developmental stage. And in order to do that, you need partnerships, you need training from indigenous leaders.
yeah. But I think one interesting session you must watch is the one with David Shimoni from Israel. He's done a very interesting research with the Jews that came from the Balkans into Israel. So his obviously the whole traditional system of their having the rabbi and looking at the rabbi to help them resolve the dispute. So that aspect was definitely there. So you're a little distracted. I'll wait.
No,
Once
I'm
you
not distracted.
no, I'll wait. No, because this is important. I'll tell you this one. This part is really
The
important.
rabbi, yeah, having,
No, the
I
point is
heard
that
you.
these are the traditional things that they had. Now, what basically from that, what interesting model that he's tried to bring out from that is a hybrid model. He says, look, the
Mhm.
rabbi and all obviously had this tendency to tell them what to do, or they told them what to do. So that definitely goes against the concept of mediation. And also with other people we were discussing, and how in the traditional system there is a power imbalance situation, and sometimes it is not taken care of by these, as so we call, traditional mediators. So we have this, his hybrid model is modern mediator and a traditional mediator co-mediate. So the modern mediator, look, we're using the word modern mediator. It's just for the sake of usage. You can call them whatever, because it's traditional here, so modern here. But the fact is that they co-mediate. So this modern mediator can take care of these issues. Like Viraj in South Africa was talking about her having people coming from villages and all, who in their traditional system don't get a voice. The women don't get a voice, but here they get a voice. So if this kind of a hybrid, I think this seems to be a kind of a missing link which I was looking for. I think I found that there. So we have the traditional there, so they do bring in some good things, but wherever the negatives are there, we can balance it out with this. So that seems to be something which we work on. We'll work on it. It's just he's put this thing out, so we'll discuss it. But it seems to be something interesting that we can work on. But now, Rosalia, what about the court system? What is happening in the court system? What are mediators being paid in the court system? Any
In the
idea on
court
that?
system.
Yeah.
The court system, the mediators are being paid just like lawyers. I mean, no, they're getting well paid, because they're incorporating it into their private practice. So whether you do a mediation or you go litigate, you're basically paying for the hourly rate of that lawyer.
No, what
So
about
if
this?
you
No, I'm saying about the mandatory mediation and all.
pardon,
Is there a mandatory mediation situation happening?
the
Eh,
mandatory mediation is in family law.
Yeah, but in that,
And
are these
in
people?
the other, in civil and commercial, like I said, it's recommended. So let's say, for instance, let's say I come and see you. I come and see you and I say, I have a dispute, with, this guy did not, I have a contract which, he's in breach of this guy's in breach of contract. Okay. So I'm complaining. And so what do? You as a mediator, as a lawyer, as my lawyer, you're going to say, okay, let me speak with so-and-so's lawyer and see if we can resolve this through dialogue, through mediation. Let's see if we can come to an agreement, but you're still going to charge me your hourly rate.
No, because I'm
That's
just
what you're
thinking,
going to
yeah,
do.
okay, okay. So basically, like what, yeah, in most countries now, what they're trying to do is that within the courts, they have these court annexed mediation centers, and then judges they refer the matters there, and then they have a pool of mediators who kind of get paid nothing. So that is spoiling the system of mediation in most countries. So that
Hmm.
this whole concept of getting it for free situation that is happening, that is a bit of a worry, because the profession, how does it develop when everyone's getting it for free?
Yeah.
So that's
Yeah.
a discussion. If
The ones the
yeah,
the people that are going for the free mediation, I'll give you an example. Okay. You're not going to find somebody from that has a commercial dispute. Let's say the owner of a store. Okay. I'll give you an example. The owner of a store. You're not gonna. It's very rare that you're gonna find him going through public, what do you call it, a free mediation. He's got too much to lose. Okay. He needs a proper settlement. Like in his mind, it's like he wants something written, and because community mediation, there's nothing written. Okay. It's different approach. It's relational. It's discussing, how do you feel, and you make the parties talk. It's a different approach than your principled negotiation and, what do you call them? I hate to use those words: transformative, facilitative, evaluative mediation. The lawyer's going to use. It's a different approach. That's
yeah,
that's that's a big distinction. I forgot to mention that. Okay. uh, it's the mediator has less control. It's the control is really, I mean, usually in mediation, the parties are supposed to be in control, but in a commercial and civil mediation, as well, the mediator has a bit more control of the product. You assess, you kind of, like you can assess, and you create a plan. But in what I noticed in the community mediation, which is free, okay, for me it's like okay, pick up the phone and let's start talking. That's the way I see it.
That's the way it should be. That's the way it
No, but
should
I
be.
let them talk. Okay,
Yeah,
like I
yeah.
really like. Oh, this is easy.
Mhm.
You just, you let them vent, and then and then you say, okay, you ask the open-ended questions, but they have to come up with the solution. You can't even suggest a solution. You just, how do you feel about this? What about how can we support you? Those are the kind of questions, and I'm like, okay.
Mhm.
This is I've had to change my mindset. When I do that, it's like, okay, I should have been doing this when I was a student in law school. Like
Yeah,
I'm doing
yeah.
something different now.
But with this, we haven't discussed. What about the concept of mediation in schools and all? Is there something happening there?
Mediation in schools. Okay, that's okay. I remember. And I do know that they have clinics. Okay, now they have mediation clinics. Okay, but the thing is this: because of the bar associations, okay, they're restricted. They cannot give, first of all, when you have a legal clinic or a mediation clinic, the students are not allowed to give any legal opinion. Okay, that's the first rule of thumb that they have because of the bar association. Like, because the bar associations are very, what's the word? The territorial
Yeah.
when it comes to, they have to protect the legal profession. Basically, that's what they're there for. You're paying your dues, you're paying your fees, your annual fees. So, the lawyer doesn't want to lose his business, like you just told me. Okay. So let's say the legal clinic, okay, the mediation clinic, okay, which is at, I'll give you an example, Université de Montréal, okay. It's supervised by a professor that teaches mediation to the law students, okay. What do the law students do? They could give for that, it's for them to delve into the practice a little bit more. They could give presentations. If somebody goes to consult them, they could say, okay, this is what you can do, but not give an opinion. And these are the resources that are available out there. Okay, and if you need a mediator, well, there's a list. We have a list of mediators, accredited mediators. I'm on the list for the, depending on their specialties, whatever the area that they're, if you're dealing with elderly mediation, you just go down the list. But the student can't tell you, take this mediator. He's going to say there's a list, go on this website, and you can consult what mediators are available for the different subjects. That's as far as they can go. They can't go much further than that. They can start a discussion, they can start a dialogue, but they're limited. They're very
Yeah.
limited, and it's just for them to get a feel, so that they get a little bit of practice. And then a lot of them are involved in those, what do you call them, those moot, not moot,
Competitions, mediation competitions.
yeah, mediation competitions.
No, but I'm just thinking that's good. Look, I look at it very differently. For me, these children in schools are already doing it. Everyone is already doing
Oh,
it.
peer
It's not,
mediation.
they're already doing it within themselves. Without calling it whatever name they want to call it, it doesn't matter. That informally everything is happening. So I want those children who are doing it to be brought forward, and they should be the ones to be part of the profession. So we have to do that whole identifying process in schools, communities, and take those people forward. I think that's the missing link, where why
Yeah,
the profession is not taking off, because these people who have the natural ability, they obviously go on to other areas, because it's not a profession which is paying enough for people. So we have to be able to channelize those people into the profession. So that, Rosalia, you have to think about how to do that.
me.
How? Yes, you are the government now. You are the government of Canada.
Okay, okay. The way well, first of all, what I see with that, okay, the peer mediation. First of all, do they like that? For me, okay, I'm a proponent of freedom of choice. Okay, in the sense that you have to do what you love. Okay, in that sense, okay, which is why I love mediation. It actually, it's conducive to my temperament, and I like bringing people together. And I realized that, I mean, I did litigation, I found it interesting, it was fun at that time. If I have to do it again, I don't know about that. I'm not so interested anymore, because I was different. I was younger, I had more
Exactly.
energy, or whatever you want to
No,
call
no,
it.
no, no, change your mindset also. As you
It's
grow
my
up,
mindset is
yeah,
different.
exactly.
My mindset is different, and I know what changed it also. It's the fact that I saw what consultations, I saw what dialogue, I saw how productive dialogue is. I saw that glint when I would sit down with when I started doing not only the consultations but meeting with the stakeholders, in the committee meetings, and talking to them one on one and resolving issues. They would come to me and say, we have this issue. It's really and I was okay, let's go talk. We would go have a coffee together. I still remember it, sit down, have a coffee together. Okay, how can we resolve this? And it's like, and they were saying, if we don't resolve this, I'm going to go to the media. And I'm like, wait, before you go to the media, let's meet with, you know what, I'm going to set up a meeting for you. That's where I was. I don't know if I'll set up a meeting for you with the deputy minister. Let's sit down. And why don't you tell him your concerns? Tell him how you feel. Let's see if we could find a solution. And those were the most productive meetings I ever had. And not only productive in the sense that I came out of there, I would come out of there and I would say, wow, that was fun. I liked going to those national meetings, sometimes it'd be 3 days at a time. Like we would have the formal meetings in the conference room, but the most productive work was not in the conference room itself. It was outside at supper time, at lunchtime, a coffee break. We would sit down and we would discuss, okay, you know what, call me next week. I'm going to set up a meeting with our deputy minister. I would go back to the office, go see the directors and tell them, listen, let's set up a meeting because these are the issues. This is what's going on. These are the issues. These are the issues that are going to come out. This is what's being said, and if we don't resolve this, it's going to explode. Those were the kind of discussions I was having. Okay. And I remember I felt good. And then, okay, fine, set it up. Set up the agenda, invite them, blah, 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 and take the notes, of course. Then you become the note taker. But it was fun.
But what I think, Rosalie, what I'll need to do is let me cut the live stream here because of the fact that no one's ever going to watch it. Now it's already 2.5 hours since this session has gone on. The other 2 hours is a different thing. So
Okay.
let me cut the live stream here. I think we'll continue our discussion. So anyway, thank you very much, Rosalia. Always, like I said, always nice talking to you and for your excellent presentation. Thank you very much.
Thank you, Vikram. And I guess we'll see you in the next symposium and in the next